Hello guys, welcome to this episode of administrative law. Today we are going to examine application for judicial review in Kenya. So there is a statutory provision for judicial review application process. The application procedure is given by Civil Procedure Rules Order 53. So the first step basically is the application for leave of court. So we need to note that leave of court simply means seeking permission from the courts to do something that is not normally done. So the first step is usually seeking for this leave of court. Order 53 of the Civil Procedure Rules provides the time limitation. The law is very strict when it comes to statutory. You have to file your application for leave within 6 months of the date of your application when it comes to statutory. Time limitation is not stipulated for mandamus or prohibition, but it is required that you file your application within a reasonable time. So if we have a stay of proceedings, a ruling by a court to suspend a proceeding or trial temporarily simply means that we are in a situation of a stay of proceedings. So Order 53 of the Civil Procedure Rules says that grant of leave to make application can operate as stay of proceedings. It can be a stay of proceedings you are complaining about. So in the definition, stay of proceedings is a ruling by a court to stop or suspend a proceeding or a trial temporarily or indefinitely. So the grant of leave will operate as a stay of proceedings where you are seeking to quash whatever has taken place under the quashing order. A stay of proceeding will apply in case of statutory and prohibition and not a mandamus. So the first step, as we have put it, is to seek the leave of court. After being granted the leave, we talked about, we said that the leave of court means the permission from the courts. And then after being granted this leave, you will make your application by way of notice of motion, which includes a statement. So what is a notice of motion? A notice of motion is a written application to the courts. So within 21 days of the grant of leave, you must make your application. If personal allegations have been made, you must serve the party that the allegations have been made against within 8 clear days of hearing. Then you proceed to file an affidavit of service stating some things. So what is an affidavit of service? It is simply a proof that official paperwork has been served on or delivered to its proper recipient. And affidavit is a type of verified statement. And a verified statement simply means it may be an oath which has been administered by a relevant state official. So there is always a penalty of perjury, especially when we talk about an affidavit, because it involves oathing. So the function of the affidavit is to let the court know that an individual has received some legal documents. So the affidavit must be filed within 8 clear days of hearing, and file the affidavit with the court registry. and the affidavit must be in file in the day of hearing. So after that we go to hearing. So in hearing, basically the court listens to your allegations and makes a hearing. The court may rule in your favor or not rule in your favor, and that will complete the application and hearing of judicial review, especially in the Kenyan context. Like, share and subscribe.